dive in now because I get to introduce people and make them work. I'm going to start with Farheena is in the middle. Farheena recently left the PTO. She had a number of interesting positions. She was the solicitor and deputy general counsel at the PTO. She also did a stint trying to fix the board for a while as a deputy acting vice chief judge. She was with the office for many, many years. She's had her hand in a lot of decisions, and I think one of the things you'll benefit from her today is hearing a lot of the thought process of the PTO in how they do their job. Yasmine is with Bonnabry in Paris. She's admitted in the New York and Paris bars. She serves as a UPC representative. She advises clients on all areas of law, but she has a particular focus on the life sciences. And she is going to give us some of her experiences with the UPC process today. Alexander is a German attorney at law specializing in patent litigation, also at Bonnabry. He's been doing this for 25 years. Yeah, that's great. I know
maybe more because this is the time I'm already starting not to add new years,
Well, I like to think if you measure us in our age based on our billable hours, we're about 75 years, 100 years old, 110. Depends on how much work you do. In any case, he's a great resource for us today because he litigates in the UPC, in German patent courts, in German Federal Patent Court, and in the European Patent Office. So what I'm going to do is hand it over fairly quickly so they can go through their slides, and then we're going to come back and have a conversation about some of the interesting issues about revocation proceedings as part of the broader campaign for litigation. So we're going to start with who? I think you're up first.
Okay, then I put on the microphone and I'm going to start because what we we were putting some figures together and in order to show what are the success rates invalidating patents in the different forums in Europe. So starting now, and here's a slide on the. Maybe you can.
Yeah, I know. I was just thinking you can't turn your head that way.
This is not nice. Would be great if I can happen.
Yeah. I just have to find it very quickly.
But I can continue. We have the opposition possibility at the EPO. I think comparing it with the United States, this may be comparable to the post-grant review situation where you have 9 months period after grant to file an opposition and to get invalidated the patent. And on the slide, I had added also the numbers, which are quite high. So many competitors, they are using that system in order to get a patent invalidated through the EPO. At least I think it's around 2,300 cases per year filed and also decided by the EPO, by the opposition division, and later then by the boards of appeal. And this is, in my view, amazingly high because from the numbers, you can also say that it is not necessarily a forum which is patentee friendly. So, and this is something what you also see. What are the reasons normally invalidating patents with the EPO? What practitioners are saying is you need to have really, really good prior art in order to get a patent invalidated through the EPO. And the chances to invalidate a patent is more on formal reasons, such as added subject matter. And it also can be seen by the success rates, which are in a way, to get a full revocation of a patent is around 25%. And you have then the situation where the patent is upheld in a limited form, this is 46%. But if you take both together, you have really more than 2/3 which are not staying in that, in the form as granted. Unfortunately, it is not visible through the statistics whether this really helps the patentee, because sometimes you get a amended claim which is not then readable anymore on the infringing device. So can't say it. But of course, the EPO is used by companies to invalidate patents. And now, if we compare this, for instance, with the US situation, post-grant review is a system which is not used as much as we would expect, because it's a kind of the counterpart. And so if we now continue with and I think it is also important to get an impression about the German situation, because Germany is known to be patentee friendly. But if you look on the numbers of invalidation, or let's say the invalidation chances through the Federal Patent Court, you can realize that it is not as patentee friendly. It is even it's even the Federal Patent Court a forum which heavily invalidates patent. And we have that injunction gap, because here might be also a clash between the infringement courts and the Federal Patent Court, because the infringement courts, they do not judge on the patents. They rather have the possibility, or let's say as a defendant, you have the possibility to get a suspension of the proceedings if the let's say the likelihood is sufficiently high for the infringement courts that you are going to be successful in the invalidation proceedings. And as you can see here, you have a court which is more or less, quite patentee unfriendly. But the unfortunate thing, and this was always criticized by many worldwide, that normally the suspension rate in infringement courts is pretty low. So you really need, in order to get a case suspended, novelty destroying prior art, and arguments such as inventive step are normally not heard with an infringement court. And this made, in a way, the situation very favorable for patentees to start litigation, because then they get an injunction, and the injunction is enforceable against a pond in first instance. And the simple risk that that you could, in a way, enforce the patent is, in many cases, was sufficient in order to get a kind of a deal. And I think that is some of the idea which was also sold by us, to have that injunction gap, and you try to get, in a way, a settlement during that injunction gap, because maybe if you then have your case at the Federal Patent Court, you might be losing it, or it might be limited to an extent that it's not falling anymore on the patent. And now, coming to the UPC, here I see a situation, because I was looking on this, trying to find out whether, in particular in the telecom area, a company like an NPE is continuing litigation on a national level, or is he going maybe to use the UPC? And here we can see that the success rate in order to get an invalidation, or let's say a revocation of the patent, are better than at the Federal Patent Court, definitely. And if we go now on the next slide, you can, unfortunately I have that number, you can say that that in the in the situation of a telecom patent,
Right.
it is quite favorable, you can say, for someone who has a telecom patent to litigate in the UPC. So therefore, I think that's a signal that also in the future there might be more, NPEs trying to get cases running on at the UPC, because simply they see that it's not what they expected, that the UPC is in particular in the telecom area negative vis-a-vis the patentee. Rather, they are in a way in a situation where you can say that it's a place where you can go and try to get your patent enforced. In particular, if it's an NPE with more than only one patent against the product, then of course what we discussed a few minutes ago is if you have 3 patents against the same product, then you can easily take the risk to file. It might be separated, it might be separate cases, but you can take the risk to go through the UPC, because if you win in only one, or if you win in only one, you have already achieved what you want.
I have a quick question. So I heard earlier that there's counting at the UPC for each patent challenge, or are they grouped together in sets of patents that will be proceeding in the revocation actions? These are like the 364 and 72 numbers are individual patents. That's how many patents are in play, or is that?
These are individual patents.
Okay.
I also believe, because for the time being we have, of course, some statistics, but they are already a little bit outdated. They are from a couple of months ago, and I added to this number something which is normally the ratio over the time. But these numbers, there are definitely numbers which are counted on per patent, and even so, if you take both numbers together, counterclaim for revocation plus infringement case, it's, normally it could be considered for someone in the United States as one case, because
Right.
it's all done in front of the same panel. But here we say that it is legally a new case, and you get also a new docket number, even though it is in a way the day of the hearing be heard and pleaded in front of the same panel. So normally this starts in the morning with a discussion on whether the patent is valid or not, and in the afternoon you talk about infringement. But due to the fact that it is so so a short time to get something discussed in one day, you cannot be sure that they are going like the French people are normally doing. They start with it's also logic to start with whether the patent is valid, and then after you go down and you talk about infringement. There you can sometimes we experience cases where the judges are coming in and they are just trying to, in their preliminary opinion, to navigate through the proceedings. And of course, it's more a written proceeding, and therefore, in most of the cases, they have already the decision in their mind, and they're only then checking,
Testing right.
the lawyers whether there are some arguments, and then they would, in a way, do what they know already, decide in a particular way. But was always, in a way, the tradition in Germany that it was rather the exception that you are in a hearing and the judges did not yet know. From the preliminary opinion, which is the normal way, what we know from German proceedings, what the presiding judge is giving at the beginning, you get a strong feeling where you are.
Yeah.
And of course, it happened. It happened to me that we overturned the situation, but it was really rare in a situation where there was a clear misunderstanding in the panel. And that's, I think, for the time being, that what I have here, and you have
then we'll go to Yasmine.
No, but let me only start. This is one of the reasons why the EPO is so patently friendly in my view, because they have a clear way of of analyzing inventive step. In the United States, you talk about obviousness, and this makes it predictable, very predictable. The EPO case law. On the other hand, it's patently friendly, and sometimes from the implementer side, it is felt unfair, because if you start really formalistically always from one piece of prior art, then you could end up in a situation where simply you feel that this is not completely correct, and also the people, the skilled person of the art normally does not always start from one piece of prior art. But I know I give you the floor to explore how this is now different with the UPC.
And one interesting question is what happens when there are parallel proceedings, like when there are EPO opposition proceedings and in parallel UPC revocation proceedings. In this case, the UPC has stated several times that they will not grant a stay of the proceeding merely because there are parallel EPO opposition proceedings. But the UPC also stated that if there's one body that upholds the patent and the other ones that revokes it, it's the latter decision that will prevail. So in this case, there's one remaining question is what happens if both uphold the patent in different forms? There's no answer yet, but we'll see what happens in the near future. And a second interesting point is that in the case of parallel proceedings before the EPO and the UPC, well, before the EPO, you have 9 months from the grant of the patent to file opposition proceedings. So it can happen that you find out about a new prior art after this 9-month window. And in this case, what you can do is to use UPC revocation proceedings to file this new prior art and to have a second chance to invalidate a patent when you're on the defendant side, of course. I would just... the third point that I wanted to make you notice is that there are differences of interpretation in the inventive step assessment before the EPO and the EPC. So, for example, before the EPO, a prior art is usually just the most promising starting point for arriving at the invention, and the EPO will only take into account one single document. Whereas before the UPC, there's a more flexible approach that has been taken by the judges. In the recent case law, we can see that the UPC decided that prior art could be documents that would have been of interest to the person skilled in the art, and the UPC judges are also keen to admit several prior arts and different starting points instead of just one sole document. This can also be explained by the fact that the UPC is the composition of the panel is legally qualified judges as well as technically qualified judges, which is not the case before the EPO. So the approach of the inventive step assessment before the EPO is way more strict and rather narrow. And third, the next slide, sorry. The other point that I wanted to make you notice is the role of expert evidence before the UPC and the difference with the national courts. So we know that in Germany or in France, for example, expert declarations are very often filed, but experts are very rarely heard during hearings. In the UK, the expert declarations are like central in the UK proceedings, and in the Nordic countries, the judges may question also the expert during the hearings. Before the EPO, only expert declarations are submitted, and usually it plays a limited role. And before the UPC, well, in the case, the PCSK9 case, Sanofi against Amgen, the Munich Central Division stated that those expert declarations may be useful, of course, to provide proof of certain facts, but the judges will make the ultimate assessment of the relevant facts and the circumstances, which are a question of law. And so the UPC is trying to use those expert evidence as a way to assist them in making certain finding of facts, but the ultimate assessment is made by the judge and the court itself. But recently, there has been a case before the Munich local division, the Cabacitaxel case, which was between Sanofi and Stada, Zentiva, and Dr. Reddy's. In this case, the court has heard for the first time expert testimonies during the hearing. And it was interesting to see how it can be different from the classic US or UK cross-examination of experts. So first, a few weeks before the hearing, the judge has sent a list of questions that he will ask to the experts during the hearing. And he also tried to limit those questions to specific points, specific prior arts, and like the most contested points of the case. And the hearing took place in October, and it was a full-day hearing where the experts were questioned during 2 hours, 2 or 3 hours. There were first questions asked by the judge, and then questions asked by each counsel's parties, each party's counsel, sorry. And it's also interesting to note that the Judge Sigan during this hearing specifically said that this would be different from US or UK cross-examination proceedings. So yeah, we see how the judge wants to really limit the questions that could be asked to the experts.
We're going to come back to this. All of us in the U.S. are completely obsessed with this question of hot tubbing of the experts. So we're going to be entertaining ourselves by looking into that. All right. So Farheena, you have to do the impossible thing, which is turn your head exactly backwards.
You know, I have a paper copy, so I can run through it, I think.
Right.
So Alex, you had started off by mentioning the counterpart to the EPO proceedings being the PGRs, and why we don't see as many the same rate of PGRs being filed in the U.S. And that's true. Historically, PGRs are about 5% of all of the AIA type proceedings that are at the agency. But when you look at it in the context of the number of patents that the United States Patent and Trademark Office issues, it's sort of, you know, it makes sense. You know, we've got, I think we're at 12 million plus patents right now. The grant rate is extremely high. I think upwards of 70 to 80%. And the number of live patents that exist right now are close to about 4 million, 3.9 million, based on the USPTO slide. And so when you have that many patents, it's kind of hard to get in within the first 9 months to kind of evaluate fully whether or not you're going to challenge it. Some industries are, you know, are prone to doing that. The life sciences, I think, are very keen on this because they're very much attuned to what the competitors are doing, and so they are monitoring. But there are just so many patents in the other areas, especially in the electrical side and the computer side, that it's not really as feasible. So I think that's why it's also, you know, very stringent estoppel considerations, because you can raise a lot more issues in a PGR as opposed to an IPR. And so those concerns also, I think, discourage folks from applying. But, you know, these figures are interesting, but obviously currently what's happening and John Whalen alluded to this, is there's just been this completely dramatic shift in IPR practice compared to historic norms. It's really been turned on its head. I think John had said it right. It was 2/3 versus 1/3 denial previously, and now it's the other way around. And most recently, in light of the summary denials under Director Squires, we're looking in close to 20% of institution rate in some instances. So there has been a very sharp decline in proceedings at the agency. There are three types of proceedings, and I know you all know this. There's the 2 AIA proceedings, the inter partes review, the post-grant review, and there's also re-examination proceedings that are post-grant proceedings that have existed since 1980. Yeah, no, that's okay. So in this slide, I think we were just showing, sorry. We were just looking at comparing, what's happened when in the first half of the year. The fiscal year for the United States is from October to September, so not the calendar year. And so when the prior to the new administration coming on board, where the PTAB panels were handling institution, you had a institution granted 66% of the time, denied 34%. Once the director came on board, that really has shifted, where you've got a denial rate of 60% and a referral rate of about 40%. So this is a huge seismic shift in how things are happening at the agency. It's going to have ramifications in district court litigation, and it'll be interesting to see if it has ramifications in Europe as well, in the UPC. The next slide, you had also mentioned, we were not sure which court is more patent friendly, whether it's the EPO or the UPC. I can tell you right now, the PTAB is the most patent friendly court tribunal. I would almost go in so far as to say it is the patentee's best friend at the moment. Patentees are sitting patent happy, but I think there are some certain considerations that they should also think about and not necessarily take current dynamics for granted.
You think it's a friend the last 9 months, or?
Oh no, last 9 months.
Okay.
But John, I think if you look at this slide, right?
Yes.
Oh, okay. Well, it kind of depends on how you look at it. I mean, there's an argument that the PTAB has always been patentee friendly. And the reason I say that, and these are numbers from the Patent Office, it's because when you look at, you had talked about decisions where all of the challenge claims have been invalidated. And when you look at that number, it's 17%, which is nowhere near, an astronomically high number.
If you look at the number of final decisions,
yeah,
when estoppel applied,
right.
it's 65, 70.
That's because it all depends on how you're counting. I give you that.
And I'm not blaming you, but the PTO got the game of spinning the number.
All right. Well, I went down this road because you had asked, but I do think there is an argument to be made. This idea that the PTO was not patentee friendly, I think the numbers speak for themselves. So it's something to think about.
I don't know what you think, John, but
Yeah.
if I go through my favorite people on LinkedIn,
Yeah.
I don't think they're going to agree with you.
It might be true. It might be true, but I'm just talking about what the numbers show in terms of overall.
What numbers you were selecting show?
This is the PTO's numbers, not my numbers. That's the PTO's
Well,
numbers.
I would trust your numbers. I'm not sure about that.
Okay. Well, this is the PTO numbers, including the discretionary denial numbers under this administration. So just putting that out there also.
So for everybody in the audience,
Yeah.
the film, this has been a long-standing issue about the numbers versus the general feel of especially small patentees, folks like Josh Malone, that group.
Yeah.
It's
Yeah.
always been that gut feel that the PTAB, based off of Judge Rader's comments, which he didn't show up, so we can talk about it today, that it was a patent death squad. So
That's right. Yeah.
this is a long-standing you should
I'm
make a
I'm
statement to
just
the
I
council.
I didn't know how hostile this audience is going to be, so I'm just going to
John started it.
just
He
stay
did.
low right
He
now.
did. But I can take John, former solicitor. I can handle John. All right.
You want to talk about this one?
I was here. I was just trying to show you the comparison between the prior year, fiscal year, versus the current year, just to show you how drastic the change has been with the discretionary denials. That was my only point
And I'm
here.
not a
So-
fan of what they're doing now.
Yeah,
Yeah,
so
and-
46% denials currently, and that's up about, it used to be 28%, right? So it went from 28 to 46% stopping them before they're instituted.
Right. Yeah.
That's a pretty noticeable chunk. This
Definitely
is the other thing we
noticeable.
love, right?
Definitely noticed.
This last slide.
Yes, and now we're in this world where we've got black box decisions. There have been two sets of these. The first one involved 13 IPRs. The next set involved 20 plus IPRs, where they were summarily denied without any sort of explanation. Whether or not the agency has the authority to do that, I think, is debatable. I was instrumental in establishing the non-reviewability bar the first time around, so I've litigated this.
Careful what you wish for.
I know.
Or what you admit on tape.
Oh no, I mean these are just facts.
Talking about hostile.
Um,
And just so
Yeah.
everybody knows,
Right.
has everybody seen
these,
this piece of paper?
Mhm.
Okay.
Yeah.
I didn't know if it had made its way to Europe.
It
Yeah.
made
But
it to
the
Europe.
single- I think it's very, very green, very efficient. No trees were
it can
harmed.
be.
13 IPRs, millions of dollars of work denied, one page.
Right,
So
That's
they,
government efficiency.
and the
So wait,
fees haven't
wait.
changed. Just keep that in mind. Yeah.
but Europe is familiar. Remember, Europe was run by the Romans, right? They got most of Europe, and there was that thing in the gladiator, this or this, right?
it,
This
yeah,
is because they're going Roman gladiator type, of actions on the institution.
So, there are lots of governance issues, I think, related to that. There's some transparency issues related to that. Whether those are litigation risks or not, those are questions that will be answered in the future. But, there are other things to kind of keep in mind. There are existing regulations in place that allow you to appeal to seek rehearing of an institution decision. I don't know how you seek rehearing of that. What do you say?
I would say you failed to read the petition.
So, there are issues like that sometimes it makes me think that we are moving so fast that we're not necessarily thinking about the consequences of, the existing structure, which has been codified in rules at the agency. Those are just some thoughts.
But there's the whole group of people that think they're moving at exactly the speed they intended to move.
Oh, I think this is completely intentional. I think that's right. Yeah, I think that's right.
It's just happening to all the other agencies, but this one's not getting as much attention yet.
Yeah. No. This is consistent with how this administration has moved across. I don't think the PTO is unique. What I think is different this is, though, that the PTO has historically hasn't really kind of felt political changes. And I mean, I understand full well that elections have consequences, but those consequences weren't always felt at the USPTO. Which is, an institution with a very discrete mission. And sometimes I do wonder whether these sorts of drastic changes are good or healthy for the system as a whole. My view is patent law is commercial law. It governs commercial transactions. And if that's right, you need stability, you need consistency. And if we have these wide shifts from one direction to another, whichever side you think is right or whichever side you align with, this can't be good for the system because it creates this sense of institutional instability. And when you think about how markets are governed, any kind of institutional instability like that weakens the system as a whole. And, I think it can be dangerous territory.
Yep. So what we thought we would do is kind of tackle a couple of different questions that parties who might want to think about starting a fight or are in a fight should consider. And I would like to start with the European perspective and say, all right, if you're the party who wants to, you see a threat, you're the potential infringer, you see a threat, and you want to take action to try to forestall that threat. What's the best path? What's the best option for you as a patent challenger? UPC, EPO, national action? Let's kind of get a sense of what the factors are that drive that choice. Now you have three choices, at least.
It really depends on the case. And
You can't answer it like that. You have to
that-
give
this
nice,
is,
clear guidance.
I have given. Yeah, thank you. It depends on the case, and in order to start, for instance, EPO opposition, you really need to know what, how you are going to, oppose the patent. And to some extent, sometimes I recommend to my clients, we have to prepare it, the opposition, but we decide really at the last moment whether we are going to file, because in consideration of a inventive step assessment, which is, more patentee friendly, I feel better in a system like the UPC, where you have a holistic approach. They call it also holistic approach, what we know also from our German federal court, where you have the possibility to somehow combine the starting point in order to get to your, let's say, to a conclusion whether it is inventive or not. And therefore, it depends on the case, and I would really want to see first the prior art which is available. And of course, if the patent has a problem with respect to disclosure or added matter, then the best place to go is the EPO, because they are very radical in terms of, and this happens often in international prosecution, that you have a US priority where everything starts and then goes over PCT, then later to the European Patent Office, that changes are made in the claim which are somehow changes not well reasoned, and they have been integrated in your application, and later when you start to litigate the patent, you realize, oh my gosh, why did they change a particular term into something else? And we are, at least the EPO is very strict on these. If you do not literally have the disclosure in your description, then you are out, and you could then also kill the patent better at the EPO.
So that's your scenario where your priority application has combined A, B, and C, and somebody shifts to make it A, B prime, and C in the national filing, and now you are going from a more generic description to more selection out of the genus, or vice versa. So you have a discrepancy between your own priority chain, and you lose your priority benefit.
I think the reason why this is sometimes going wrong is because there are differences between the US in prosecution. For instance, if in the description a range is in a way described, I think, and I've heard from patent prosecutors in the United States, that you could also, for instance, you have 5% to 10%, you could also, for instance, take the 7% because it's in between.
Right.
That's something what you can never do in Europe, and because you have only the possibility to take exactly what is written in your, let's say, in your description, what is the inventor at the beginning originally disclosing to the world.
I got a sign thrown at me in the back there. We have very few minutes left, so I want to go to a variable that often is a big question mark for U.S. litigants. What is the role of the expert in the fight, and how can that help us or hurt us in a proceeding? And I was very intrigued by the hot tub question. because maybe you can just give us a flavor for how the experts are guided when they're in the hot tub. And just so you know, this is Australia's fault, right? Australia is the first place that I've heard of the hot tub where they put the experts together in front of the court, and they let the experts kind of have the interaction directly in front of the fact finder.
Well, they might be the first people who start. Or the
But that is terrifying in the U.S. process. But go ahead.
But so it's still very well structured. It's not a real like confrontation between the two experts. Like the judge is leading the questions, asking questions to each expert separately. So yeah, it's not. I mean, it's kind of structured, and it's interesting also to see how. When the judges are sending the question before, you can also have a feeling of what will be important during the hearing and what you should advocate on during the hearing. So you know in advance what you will focus on during the hearing, and that's actually something like a real bonus compared to, for example, hearings before French national courts, where you just arrive and like plead the whole case during 3 hours, and you don't really know what will really interest the judge. So yeah, that's a good hint before.
Are the judges in the hot tub setting testing the credibility of the witnesses, or are they just really looking at the scientific questions or the technical questions?
So that's exactly why Judge Zigan stated that we are not in a U.S. Cross-examination proceeding. So there were only very objective questions about what the experts interpret from the prior art or from clinical trials, and what was the common general knowledge at the priority date. So.
But you have to keep in mind what the judges said, that you have only 1 day, and there is an inclination. We heard it from the French judge. There's an inclination not to have, this is maybe already a case which is a little bit abnormal from what is typically the situation in UPC litigation. What is, at least in Germany, I'm talking about the German divisions of the UPC, because they want to finish the case in the evening. And if you have only 8 hours, and you have to anyway to split it in 2 parts, because you start with the validity and later to talk about infringement, the situation is even what concerns time worse than what we had with the Federal Patent Court in Munich, where we have had only a discussion on the validity, but the whole day.
Right.
So I think this is rather the exception, but if we read now the rules of procedure, there is a difference to what we know out of the German law. And this is maybe because UK lawyers were also drafting these rules. The privately appointed expert should have a different position than what we know from German proceedings, because in Germany it was for a long time only the statement of the party, and
Right.
had no additional value. Therefore, they didn't want to hear the expert. But here there might be in the future a shift towards something which is then more, because it starts also with a declaration, because they have to bring a written declaration into the proceedings, that we will have something which is then, in particular, I find it not so, in a way, bad to have 2 experts from 2 sides, because to some extent it bubbles out the truth.
Yeah.
Because
No,
they are often people, they have their own, renommee, and they do not want to be somehow brought in a situation where where the other side says if you're wrong, or they.
I think we're running out of time, but I want to flag this point with Farheena. My sensation has always been that what you are describing now, two declarations go in and there's kind of like a narrowing of the issues of dispute, and then the fact finder can look at the disputed questions and do some kind of assessment of the narrower set of questions that have been engaged. That kind of feels at some level what goes on with at least the historical PTAB proceeding, right? We're all on paper. We have depositions to test kind of the weaknesses of the other side's experts' testimony. Is that kind of, I mean, give us a sense of kind of the philosophy of how the board uses expert testimony.
I think that's right, but I mean, even the use of expert testimony right now, under the current, it's another discretionary denial factor. Relying on expert testimony to fill in gaps. I mean, there's the question. Yes, you don't want to necessarily rely on use the expert to explain what a person of skill in the art would have understood. For general knowledge, and you want to rely on the prior art itself. But that line of when the expert is simply explaining what the prior art would have taught to a person of ordinary skill in the art and whether they're providing general knowledge is it's very blurry. So to use that as a basis to deny institution is interesting. It's very different than historic practice where the expert reports were very helpful to the judges. I think, John had alluded to how the board decisions, the quality of the board decisions, I do think that they've improved over time. And the reason I think that they've improved over time is because the litigants that have appeared before the board has really gone up. The quality of the litigants has gone up. You've got very big law firms now litigating in the PTAB. And that is why you're also seeing better decisions and also better use of expert testimony. So that's been the historical practice, but I do think that's different now in the current regime.
I think we're out of time, right?
You've got a couple more minutes.
Well, where I wanted to go, the only other question I wanted to kind of get a sense from the panel, one of the things I've always learned in working alongside European litigation with kind of a global campaign is the European lawyers tend to come in with a kind of analytical approach of how do we create the squeeze, right? The squeeze between the tensions. And I want to get a sense of whether in the setting of national proceeding, individual revocation proceeding versus integrated UPC proceeding where you have a counterclaim within the broader case, are you feeling that you still have all the options for squeezing when you're taking a revocation action or a national action? Or do you feel it's sometimes better to choose a place where you can kind of have them in that one day hearing to hear both infringement and invalidity questions?
I personally believe that the squeezing strategy, let's call it squeezing strategy, also applies under the rules of the UPC. So whether you are arguing the squeeze the same day or in different, let's say, forum, is at the end of the day a valid way to find something which might be either not non-infringing,
right,
or it is simply invalid, because you have to decide at one point, and it's a completely valid way how to strategize your case. And I think in particular in the telecom area, where you have notions which are not so clear sometimes, and you have prior art where you read it 10 times, and at the end of the day you even could find the infringing device and that kind of description. There the squeeze is very important for us, because then there must be the other side must take also a decision where they want to go.
Right.
And I think the squeeze can even better work in a system where everything is together, because you cannot say in the morning, I have that understanding of how it works, and in the afternoon when it's up to talk about infringement about something else.
Do you have any additional thoughts?
I would say that it may be easier to bring a squeeze argument before the European Patent Office, since they are very sensitive to, like, the assessment of the inventive step and the validity of the patent is stricter and narrower than before the UPC. Yeah, I mean, I think that in the end, it's like before both courts, it will be like a good argument. And like I also think that since there is legally qualified judges before the UPC, they are maybe more keen to hear a story about how the patent has been, how the invention has been done, and when, and what was the common general knowledge before the priority date, and so it depends actually on with what kind of squeeze arguments you want to bring.
I think what you started with was where we will end, which is your facts dictate how you're going to approach this, right? If you can tell that narrative coherently based on what you can prove, you may go into the UPC court integrated in one proceeding. If you've got a really good invalidity case and you don't want it clouded by kind of the fact that the product is now very successful, then maybe you keep that separate and you choose a revocation proceeding in one of the fora. All right, well, thank you very much. I appreciate the panel putting all this work into the remarks, and that's what we have.
Thank you.